start with a 30 to 35 minutes lecture, and after that we'll open the floor for questions. If anyone has any questions during the lecture, we request them to drop the questions in the chat box and we'll address them after the lecture is completed. So I'll request Shreya to start with the introduction.
Thank you, Manan. Happy Independence Day, first of all, and a very warm good evening to all of you. Today, we have here with us a very eminent personality and an accomplished lawyer, Mr. Sidharth Luthra. I welcome you, sir.
Hi.
To begin,
Good evening, everyone. Good evening.
To begin with his introduction, Mr. Sidharth Luthra is currently a senior advocate at the Supreme Court of India. Sir has pursued his LLB from the Campus Law Center, Delhi University. Thereafter, he pursued MPhil in Criminology from the University of Cambridge. Sir had served as the Additional Solicitor General from the year 2012 to 14, representing the Government of India in various matters relating to fundamental rights, electoral reforms, criminal law, and policy issues. Sir specializes in criminal law, white-collar crime, and cyber frauds. He joined the bar in 1991 and is also a member of the Delhi State Legal Services Authority and presently the Vice President of Indian Criminal Justice Society. Sir generously dedicates nearly 30 to 40% of his cases to pro bono matters. And apart from his accomplishments in the field of litigation, Sir is also a visiting professor at Northumbria University at Newcastle, United Kingdom, and honorary professor at the Amity University. Sir sits on the advisory board of two Indian legal journals, namely Delhi Law Times and Delhi Reported Judgements. Sir, along with the Campus Law Center, also organized the annual KK Luthra Memorial Moot Court Competition, which is a prestigious international moot court competition dealing with the criminal law. Sir, I would like to thank you for having agreed to do this session with us today. I now hand it over to you, sir, to take the session forward. Thank you.
Good evening, everyone. Best wishes to all of us on Independence Day. It's a momentary day for our country, and we hope that better things are always there to come. And as the Republic grows and matures, it is you, my young friends, who are going to take this Republic to greater heights. And as lawyers, it is our duty and our privilege to defend those who do not have access to their rights, those who are deprived of access to justice, and also uphold the Constitution and the laws. In fact, the oath in the schedule to the Constitution says that all members of Parliament, MLAs, judges, everybody must uphold the Constitution and the laws. Most people do, sometimes they don't, as you all know. But it is your job as the next generation to make sure that this happens. I am very happy to be speaking at NUJS Calcutta to a bunch of students. Always found your institution outstanding. I'm a product of a bygone age when we did not have the privilege of 5-year law schools. And therefore, we did not have the privilege of the specialization that you get. And you are privileged in that sense. But we managed, I assume, and I hope not too badly, as a consequence of which you'll have to suffer listening to me today. Now, we are talking today about litigation in a virtual era, challenges and opportunities. So one of the fundamental things that we must ask is, and we're going to deal with this, and I'll leave this question open for all of you, is virtual litigation or virtual court litigation, it is clearly here to stay, but is it the way forward? Is it partly the way forward? Has it improved the lot of those who are the beneficiaries or those who seek the services of the justice system? After all, the legal system and the justice system is not an ivory tower where judges and lawyers in their wonderful robes and gowns and bands, whether from India or from Eden Ravenscroft in England, appear in courts, talk in legalese, arcane terms. How does that translate for the litigant who only wants that his right to his land, his ancestral land, is protected, or a person who has filed a family suit, a matrimonial suit, and wants maintenance, a lady wants maintenance, or a child wants a right, or you want to seek redressal against the government which has taken away your lands under, let's say, land acquisition proceedings, which you believe are unfair, or the withholding of a payment by your employer, when that payment for a person employed as labor, can mean not just poverty, but hunger, starvation, and surviving with your food in your stomach. In fact, I've been reading of late a very interesting book, which it's your choice whether you want to read it, not by a writer called Kancha Elia Shepherd. You should have a look, he writes quite well. And on a separate note, he has written, the book is titled Why I Am Not a Hindu. Now, it's an interesting critique of how what he calls the Dalit Bahujans, or the scheduled caste, the lowest of the low, perceive how the system and how society works and how education works, and whether it's not really a religious book in a sense, but it really talks about why he believes that he justifies reservation, he justifies the need to have rights and the need for literature and writing and a representation of the identity of those who have been marginalized by society. Now, we are going to talk about marginalized people here because there are two kinds of people who come to courts. The first kind is, as a very seasoned litigant told me some 25, 30 years ago, he said, son, you're a lawyer, but let me tell you, a litigant, and he'd been litigating for 40 years. He told me, he says, you litigate for two reasons. One, if you want to deprive somebody of their rights, you litigate to make sure the person can't get their valid claims from you. The second reason is you litigate when you have nowhere else to go. When you are a person who has no access to redressal and therefore you have to go to court. So these were the two primary reasons then. And I don't think much has changed except that now your and our legal system has become greatly attuned to the needs of commerce. So you have commercial courts, you have intellectual property specialization, and you are increasing technical specialization, which is very good. A large chunk of your litigation has gone to arbitration, mediation. Why not? And mediation is a great thing. Arbitration is also good. But I ask all of you, is arbitration affordable? And the answer, I must tell you, is only for corporates. The average litigant can't afford it. Now let's leave that. That was just a side and a kind of introduction just to wake you guys up. I hope I did. On a Sunday afternoon, when you should be enjoying yourself at the cost of Independence Day. आप लोगों को पतंग उड़ानी चाहिए और यहाँ मैं हवाबाजी कर रहा हूँ. But that's another story for another day. So the one great change that has happened, and this is a revolutionary change, is that the virtual court has changed the legal landscape completely. It has had a major impact on reform of the court system. Matters which should have happened 2013-14, the e-courts project started. The high courts had not used more than 40% of the budget allocated to them. That is the maximum any high court had used. Few judges were doing e-courts, but most were not. And progress which should have happened had not happened. But last year's crisis, and they say every cloud has a silver lining, last year's crisis, the pandemic, the lockdown, made courts change. the way they delivered justice. The Chief Justice, former Chief Justice, Justice Bobde, was often inclined to say, please learn how to conduct yourself and dress and behave properly. This is a court. Merely because on VC does not change the nature of the forum you're in. This is not a forum where you should be casual or careless. Now, you must also appreciate that the problem that happened was we were not ready for this. So suddenly, we began with limited, very, very limited capacity and only urgent hearings. And this system was adapted and adopted through the country. The problem that we were facing was, and this is a chronic problem, was that the bandwidth was not in place. BSNL was asked to provide to the courts. Softwares were being tested. Video was constantly collapsing. In fact, I must share with you that I did the first anticipatory bail on WhatsApp in the country. There was an anticipatory bail matter before Justice Nageshwar Rao. He couldn't hear us. The other side said, I can't hear, I can't connect. So he said, okay, get him on the phone. So he called him on the WhatsApp and said, look, give me your arguments. I'm going to consider it for anticipatory bail. The other side was opposing, and we got our anticipatory bail order. Then it got reported in the newspapers, or at least in the legal journals. So through no fault of mine, WhatsApp is my client and they got free advertisement. Maybe I should have charged them royalty for it. So then you get, that's what happened last year. But I must tell you a little bit of the background. We had a national e-governance project of the high courts, district and subordinate courts. And the e-courts integrated mission mode project was introduced. The whole idea was to have a national policy and an action plan for the implementation of information and communication technology in the Indian judiciary, 2005, by the E-Committee of the Supreme Court. We have a very interesting system. Judges and the way we have structured our judiciary, the running of courts is really a matter of judicial oversight, because that is the way we believe independence of judiciary has to be construed. But the problem is, judges are not necessarily experts either in technology, nor are they experts in administration. Not that lawyers are, because we are the stuff where judges come from. As they say, as a lawyer, you're a jack of all trade and master of none. Having said that, the E-Committee comes up in 2004 to draw up a plan, and the Chief Justice is the patron-in-chief. Chief Justice launches the E-Courts National Portal in 2013, 7th August 2013, and the website began providing essential data, orders, case status, cause list, next date of hearing through the case information system. And while this was limited, it slowly expanded and reached a point where it went across the board, and suddenly, when we started practice, we had to traditionally go and inspect each record in the court. So if you had to get an order, you went and you moved an inspection. Then they said, we'll give you a true copy of an order. Then we started, we used to get an inspection, then apply for certified copies, and then do the work. It all had to be done manually. And young lawyers used to be paid for this. So it was not too bad a situation. At least we had something to get revenue from. But things changed. As orders, everything became online. And then most important, the litigant could say, hey guys, you did not appear on such a date. I'm not paying you fee. I've got the order also. As you say, you've appeared, but the order doesn't record your presence. And then lawyers would go back and say, sir, please record my presence. I appeared, and this chick would go on. Now, as on 11th December 2020, as per a circular by the ministry, you have 2927 court complexes which are connected by high-speed wide area network under the project, and 97.86 sites out of 2992 are conceived to be connected under high-speed WAN, which is wide area network. Last year, in April last year, I was part of a consultation where a lot of senior lawyers from different branches of law, from the Supreme Court, some from the High Court, were called for a consultation by the BJP President, Mr. JP Nadda, to give their inputs on how to get the courts up and functional. At that stage, some of us had raised a point that, you need to improve technology, improve access for those lawyers who do not have understanding of technology, nor do they have the ability to procure good systems. So I'll give you a simple example. Because of this lockdown and because of the problem with China, I needed to, I spent time in the lockdown last time. First, I met somebody who got COVID positive. Then later, my son was COVID positive. So I used to be locked up in one room because we were all in isolation. Now, I couldn't get files because if I was infected, I didn't want to touch physical files. So it took me about 1.5 to 2 months to get hold of a 13-inch iPad and a iPad Pro, because I needed to be able to mark my files. Now, all my files are stored on my device, and I just open Adobe and I have everything here, like this. Can you see that? And I now work on the iPad, I correct, I do my notes, I do it, and of course, since I'm of a slightly older generation, I still make manual notes, or I dictate a note and I keep it typed ready for my argument proposition note. But my files are now stored on that one device. And therefore, anywhere in the country, I'm able to argue. In fact, last year on 24th of June, I was stuck in a part-heard matter in the High Court and I had to travel that day. And I kept begging the High Court. I said, hear me on Wednesday, not on Thursday. And the judge said, no, I will hear you only on Thursday because I can't do it on Wednesday. And I said, ma'am, I'll be driving. She says, that's all right, Sidharth. You're a lawyer practicing criminal law, you'll manage. So I stopped short of the foothills in Dehradun, parked my car next to the police station. That is, the last page signal was coming in Geo. Connected to the hotspot. I'd been hearing the arguments while driving for 1 hour. And I was driving myself with an earphone in my ear. Not a very sensible or safe thing to do. And then we argued the matter, sitting there opposite the police station. And the judge had a good laugh. And two of my worthy juniors were with me. And they were making sure that if there was a signal drop, they were backing up. We argued the matter on an interim injunction. We succeeded, in fact. It was a Section 9 Arbitration Act. Now, the idea behind this system has been to assist those who may not be tech savvy, and there has been an attempt by the Supreme Court, by the e-court system and the government to ensure that certain manuals are issued, certain trainings are done. So people have been trained how to install the software, instructions on operating camera, microphone, e-filing procedure, payment of e-court fees, etc. And there has been an attempt. So, suddenly what's happened is, as a practical reality, you have a massive change, and a lot of people who are not tech savvy, including support staff of lawyers, have become redundant. All that photocopying is gone. Scanning is the new thing to be done. The big shift that has happened is, and I'll give you a few timelines, on 23rd March, Supreme Court starts with using the video app VIDYO, which I'm sure you're acquainted with. There's a circular number 681 of that date. On 15th April, the Chief Justice of the India directs in standard operating procedure for advocates, party impersonating, for mentioning, filing, video conferencing. 17th of April, there are problems, helplines are created. 15th of May, and this is the terrible part, they rescheduled the summer vacation. Terrible. And the 5-week period was declared as functioning, which was quite bad, although we'd been not working all that time in the lockdown. 13th of June, the Supreme Court has video conferencing facilitation rooms set up in district courts in Delhi to see whether litigants can join hearings, including in the Supreme Court. So people came to court, they visited, they were maintaining the COVID protocols and yet being able to be physically in court while the hearings were going on, and also address arguments if they so required. We have Justice Chandrachud, who's quite tech savvy and is the chairperson of the committee. And he has talked about how during the first wave, digitization was being pushed through. And remember, we didn't have infrastructure in place, we didn't have people, we didn't have vendors, and now they initially start with video, then they shifted to Video Connect, and there is a constant attempt to upgrade the system. The only problem with video, and I must share this as an aside, is one day I was happily arguing a matter before Justice Arun Mishra, and then I realized somebody else was arguing. So I got another device in front of my existing device, switched my camera and video on, and started arguing. When I finished argument in case number 2, and I went back and Justice Mishra said, Mr. Luthra, why did you go? Were you arguing in some other court? I said, sir, I put my camera off. He says, I'm asking you a question, were you arguing in some other court? So I said, yes, sir. He said, well, I could hear everything you were saying. Now, this was shocking because I'd actually blocked my camera and my sound. But in video, and this is a very dangerous thing, they have an override facility at the control room at their end. Leads to a lot of embarrassing issues at times. Now, the point that I was trying to make to you was this issue of digitization in court changed the way people would work. Normally, administration would finish 5 o'clock, 4 o'clock, 4:30 was the official time, 6:30 the registry would be empty. It suddenly became a 24-hour ability, tech ability, because it was now you have to do e-filing. So you can file 24 hours a day, and lawyers began to file 24 hours, and we began to push what is called the National Judicial Data Grid, which is one of the key achievements of the e-court projects. The whole idea was to try, as per Justice Chandrachud, to make the system meet the challenges and to ensure access to justice. I'll tell you what the practical changes mean. You're sitting in Calcutta. Prior to March 2020, I used to travel to Calcutta, Hyderabad, various places quite often. I traveled. The litigant would spend on hotel costs. Litigants would travel. So imagine, are any of you from UP? Mr. Srinivasav, you're from UP?
Yes, sir.
Where in UP?
Sir, I'm not sure if you would know the place, but it's a city near Gorakhpur.
What's it called?
Basti.
I know Basti very well, ma'am.
Sorry,
I know
sir.
Basti very well. And Gorakhpur, who doesn't know, ma'am? It's the most important town today in UP.
Yes,
And
sir.
Basti. Mukul Kumar Singh, where are you from? Mukul Kumar Singh is raised in Lucknow. Now, Mukulji, aap to Lucknow mein hai. You are from a place where there's a high court. Imagine a litigant from Noida has to travel to Allahabad. Imagine a litigant from Bhopal, the capital of Madhya Pradesh, can't go to Gwalior High Court, which is 4.5 hours away, can't go to Indore, which is 2 hours away, but has to go to Jabalpur High Court. Now, this is the manner in which people would function, and for a litigant, even within Delhi. You see, a litigant who is living, let's say, in Najafgarh, he has to travel to Patiala House Courts, or even to the Delhi High Court, or maybe to Karkaduma East Delhi Courts. It's a 2-hour journey. Carbon footprint, time, loss of employment, loss of man hours, and if you reach late, and it's a criminal case, then warrants are issued and you're running around getting your warrants cancelled. Now, it was always an issue about logistical challenges, how to travel, what transport to use, how to reach fastest, ensuring you had printed materials, managing accommodation. In the virtual world, things have changed. I was told recently by my friend, the Solicitor General, he says, Sidharth, about a few weeks ago, I was sitting on my table in my room. He said, you know what? You're sitting in a room which is yellow light. Change it to white light. So Manan and Arunama, you will see that you're looking much brighter in white light, where I may look perhaps a little pale in yellow light. That's it. That's the way systems operate. Or maybe I'm just pale. These things, change, screen presence. How do I ensure that my system will not fail? How do I ensure that my battery backup is there? How do I keep audio inference on? Every morning when I was working from a place in the hills, there used to be this vehicle which would come to pick up the garbage, and it would say, Hamari Masuri, Swachh Masuri. And at that time, if I was arguing, I had to switch off for a minute and then join back because I didn't want the judge would say, where are you sitting? I've had enough conversations about, are you sitting in your place in the hills or in the farmhouse? So this is, a change that has taken place. What kind of software do you use? Initially, we were getting used to it, and I didn't know how to use Jitsi. I didn't know Jitsi should be opened in Chrome. So when you open Jitsi in Safari, the video doesn't always work. And one day I was trying to get my link in Jitsi from Allahabad. I didn't get in, and then I just told my junior, there's an old link on Jitsi, just open it. He opened Indore High Court instead of Allahabad High Court, and I appeared in Indore, and I started arguing my matter at 2 o'clock, and the judge said, he recognized me because I'd done a matter from, I don't think, Mr. Luthra, you're here in this matter. I said, yes, I think I'm in the wrong High Court. So these are logistical challenges. It's also the challenges of one who's a dinosaur, like myself. The other peculiar problem is the number of platforms we use. So some courts use video, some use Cisco WebEx, some use Zoom, Microsoft Teams, Jitsi, free, open source, outstanding. Uttarakhand High Court is the most outstanding service, very impressive, and it's an open court system. Some use Blue Jeans, some use Google Meet. So how many do you have? 7. My question is, why 7? Why can't we have standardization? Incidentally, I must tell you, there's a case on criminal law guidelines and guidelines for criminal courts which I had argued, where one of the guidelines we had sought was to have uniformity of systems of virtual courts. Unfortunately, that has not got determined, but that matter was left to be decided in some other case. So when it gets decided. By that time, a lot of water would have flown under the bridge. I mean, it's the simplest thing is today, your filing is not standardized in India because some of the high courts say we are much older than the Supreme Court of India. Why should we listen? We are chartered high courts. We have our own history, which is true. But now that we are in a virtual era, can't we have standardized systems of filing and appearance and recording of materials? Systems. Now, what is interesting is that despite all these challenges, virtual courts allows you with a smartphone to access any court in India. Law students can get online internships, though if you ask me personally, the pleasure of being physically in court is something which you learn not from what the person you're working with is doing, but you learn from others and from their mistakes as also what they're doing right. So I'll tell you, there have been some amount of challenges. The first and most foremost is technological infrastructure is lacking. I have my office in Defense Colony, and one of the big problems is we have arrangements in place. We have at least we have fiber optic, we have others, but the pressure on the internet service providers is so high now, and their building capacities that it often collapses. In fact, at my place in the hills, because the pressure is lesser, it is much easier for me to do my conversations than I can in Delhi. The Parliament Standing Committee, in its 113th report, had talked about the connectivity divide and step-up efforts to timely implementation of National Broadband Mission. And that the judiciary should also consider using such innovative steps as launching mobile video conferencing for benefit of lawyers in remote areas. There are economic roadblocks. Everybody can't afford, you have a situation where people are not earning enough because of the lockdown, not enough cases are getting listed. And yet you're having to upgrade to technology. You have your fixed running costs, your office, your rental, your staff, limited revenue, and at the same time, the need to upgrade technologically. The need to get staff who are able to cope with this. 4% of your population, about 65% of the population fall under the rural category. And most persons who are dealing with litigation disputes don't have access to smartphones, digital tablets, computers, etc. There is also lack of digital literacy. You heard yesterday that Justice Ramasubramaniam described Justice S. Muralidhar, Chief Justice of Odisha, as the Steve Jobs of the judiciary, or Justice Madan Lokor, or Justice Badr Gurez Ahmed, Chief Justice Badr Gurez Ahmed. These were exceptions of, or Justice Sanjeev Sachdeva in Delhi, who are exceptions to people who understand and operate technology. Most people of a certain generation are not as tech savvy as you guys are. What has also happened is that, and this is a criticism of the court system, that the numbers have increased to 3.68 crore cases in March 2020, 19,000 district and subordinate courses, the cases have gone up 19%. Two things. Filing has become easy. But if your court set at 11 or 12 o'clock because of technological or other reasons and are not hearing final hearings, then your backlog is just going to multiply. Your numbers are going to multiply. And the other problem is, of course, as you all know, you read in the papers, we don't have enough judges, and judges are not being appointed. Again, a byproduct of, amongst other issues, the pandemic. You have disturbances in court with people singing songs. One day early on, I had this peculiar experience where there was a lady who was chopping vegetables in her kitchen, and the husband must have been wanting to use, the lawyer husband must have been wanting to use the same place, and he left the video on, and we were all we were all peering and trying to see what kind of tasty food she was going to be making. And then there was a time when a lawyer was found smoking on camera, a hookah, and another time where a young lady was putting on her makeup and telling her junior, listen, let me get appropriately dressed, I have a court appearance. Or people, talking in casual terms about the court they're going to appear in before. And these are aberrations, we're all learning as it goes along. There's also concern about hacking and cybersecurity. The worst part is trials are not moving. We do not have the infrastructure of trials. We have various high courts which have issued video conferencing rules. Delhi High Court, I believe, Chandigarh, Punjab, others have issued them. But you just don't have the infrastructure in place. Last year in May, I was attending a seminar, of course, online at the University of Cambridge, where I learned a very interesting thing. In 3 weeks, I think it was 6 weeks, they completed a murder trial from start to finish. That is, from the day they opened the proceedings, indictment, to the end. How did they do it? They used 3 courtrooms, 1 courtroom for the lawyer, 1 courtroom for the judge, 1 courtroom for the litigants. Now, the fact of the matter is we have enough infrastructure. We can actually run our VC hearing proceedings from home, but if you keep a trial on, the judge can sit in his chamber, the court staff can monitor the witnesses in one room by maintaining safety standards, and the lawyers can operate virtually from their residence, knowing that the witness is not being tampered because the witness is in a separate room, and the same existing infrastructure can be used. There are various, permutations and combinations that can be applied, but are they being applied? Tragically, though we had sensitive courtrooms made for children and for victims of sexual offences, we have not been able to even utilize them to appropriate capacity because they have a VC facility and they're 1 courtroom in each district in Delhi. This means that under trials who are incarcerated or people who are waiting for a decision are suffering. We've had times and periods when trials have begun. Some courts have opened and then shut. And at least outside Delhi, beyond Delhi, trials did begin. In fact, trials even began at places such as Uttarakhand, UP, Haryana, Punjab, and other places. But trial courts, even if opening, have not been able to conduct trials. Most of it, the time has been spent on hearing matters, which is oral arguments. Sometimes virtually, sometimes physically, but that's the reality of life. And the reason is, and I'll give you the numbers. Let us say a trial court has 40 cases in a day. That means at least 1 or 2 prosecutors for that court, correct? In each criminal case, there will be at least 1 police officer coming. So that's 40 police officers in the courtroom on that particular court. On the private litigant side, there may be 1 or more accused, correct? So you have, let's say, 2 accused per case or 3. You have 80 people coming through various points of time. Apart from which, you will have 40 lawyers and perhaps their assistants, so another 40. That's 80 plus another 40 clerks, so you have 120 people. So each 40 cases will have 5 persons at least coming, for 5 to 6 persons coming for each case. And this is including the court staff and the judge and that backup. So each room is going to attract a traffic of 200 plus people a day. And then there are the journalists and others. And it's an open court, so anybody can come. So that's the kind of danger you have in opening up courts. And therefore, I think till we get rid of this pandemic, the problem is your courts are not going to be doing trials as much as they should. Lawyers are in financial constraints, and the reason is simply this. I appear today in various high courts at a fraction of the fee I was charging when I would physically go there, because now I do it, I don't have to travel. I can't, there is no justification to charge an outstation fee. Therefore, if I appear in an outstation high court or in a trial court, the high court lawyer then appears in a district in his state, again virtually, and charges the lesser fee than he would ordinarily have charged. So the trial court lawyer has to again reduce his fee. Now this is great from the purpose of cost to client. No travel. Otherwise, imagine a litigant doing a case in the Supreme Court of India, coming from, let's say, Chennai or coming from Aizawl or Itanagar. He or she would get on the flight there, fly down to Delhi with a local lawyer, engage an AOR, engage a senior lawyer, pay for the hotel, come earlier for a meeting, then come again for the hearing. And the matter would get adjourned. Now, that person is sitting there online and seeing whether it's going on, not going on, what's happening. And the hassle of getting into court, getting out of court, local transportation, carbon footprint, all of this has now gone away. But that means there's a great impact on the economy, but that's another story for another day. The other issue is that with the second wave being as disastrous as it is in many parts of India and what is happening in Kerala still, people are now very wary of the third wave and what it will bring. So courts which were very open about opening are looking at opening physical hearings, but in a very, very limited manner. And there is a lot of protest by lawyers who term the virtual system pathetic, and who say that virtual hearings are far from satisfactory. Of course, there are problems, but I would say there are a lot of advantages also. So the first advantage is to cope. The fact is judges are working from home primarily. They don't have staff. So you need more hours to work. Now you don't travel, so you have that much more hours. Lawyers now don't travel to work necessarily, so they work from home. They save a lot of time. Efficiencies are up. My meetings happen now online. I rarely call people to my office, and all of that has added to the speed of delivery and efficiencies, not only for me, but also for the litigant who would travel from one part of Delhi or from outstation to come and see me. Carbon footprint, cost, everything, all of that is now shrunk, which is a good thing. Longer hours. I used to finish office, begin at 6:37 in the morning, finish sometime at 11 in the night. Now, normally I'm done by about 8 o'clock. Because during the course of the day, while waiting for matters, I just connect people on VC, do my conference and get over with it. I don't have to have conferences go on late till the night, because then I have to read for the files also next morning. Physical records used to have to be moved. Now you summon electronic records. As I said, cost is reduced, courts have become accessible, litigants watch what they're doing, social distancing is not a problem with VC courts, and parties are much more satisfied as they see, and the benefit of these virtual courts have also been considered by the Rajya Sabha in that 113th report. So what's the way forward, guys? The way forward is we have to adopt and adapt to the virtual era of courts, of online dispute resolution. We have to standardize practices, solutions, institutional innovations. There has to be a permanent body to overlook the governance of the system. Current E-committee consists mainly of judges, but we need representation also from the profession, from administrators, from technology experts. We have to have legislation on governing these virtual courts, because we don't want challenges on the fairness or unfairness of procedure at a subsequent era. We need to modify school curriculum, not just law school, but school curriculum, to make it more technologically oriented. We must familiarize not only younger judges, but also judges currently in the system with the use of technology. And eventually we'll have to have a hybrid model. For trials, I don't see us having the infrastructure, but we will have to continue with physical courts, and therefore the current infrastructure and the empty buildings, whether schools or otherwise, can easily be put to operating as secured environment for running civil or criminal trials, because that is something which is suffering greatly. There are, to conclude, I'll only say this, some high courts have been very forward looking. They say you can do virtual or physical hearings, like Madhya Pradesh High Court, Allahabad in some hearings. But the problem is the ability to be heard. Yesterday, I was arguing a matter for Twitter in Allahabad, and while the judge could hear me and I could hear the judge, I could not hear what the prosecutor was saying. And that causes prejudice to me and my client, doesn't it? So these issues need to be tackled. All in all, I would say the virtual court system is better. In the short term, it seems less democratic, but in the long term, I believe it will be a lot more democratic and a lot more fairer. Right now, it seems that a limited number of senior lawyers or lawyers are dominating the work. But as the work expands and as the court's functioning becomes near normal, even on virtual courts, I think the ability of larger sections of the legal profession and larger sections of the public to benefit from the e-court will become more and more apparent. Thank you very much for this wonderful time. I will now leave the floor open for questions.
Thank you, sir, for the enlightening session. So we can first start with Sujoy's question. He asks, can you share about how does a virtual environment affect the examination of witnesses, owing to the fact that things like the demeanor of the witness may play an important role in determining the veracity of the witness?
So I'll tell you what, there's an old saying, the camera never lies. Actually, the camera enhances your deficiencies and doesn't always show you the best points. So keep this in mind, and therefore it can be very deceiving. In a person may look more nervous or pale or frail or otherwise on a camera. So therefore, the angle the camera catches you, the light you're sitting in, whether your face is, whether you're tired, whether if you're tired, the camera shows greater tiredness. So all of this. So that's a problem. But in a current environment, it's the best thing we can do. On demeanor, you have to have a person in a secured environment, and one of the mechanisms they've used is a camera in front of you and a camera behind you. The camera behind you, which will indicate that there's nobody else in the room, and a camera in front of you, which records your conversation. The only thing is, litigants are always not very comfortable speaking to a blank screen. Like, I'm not very comfortable because I see Vishwas, Rajat Parekh, Arpita, Samar, Sansar, Simran Upadhyay, Devpriya, Nimesh, Somil Bishwas, all of you guys have your cameras off. So I find it very odd that I'm only speaking to Sanyam, to Arunima, Manan, and well, myself. So that's a little disconcerting even for me. So imagine what it does to a litigant who's not trained and who's not dealt with these systems. Second issue, we have always had a concept of recording of evidence on commissions, and this is to be done. And if you remember that 2003 judgment, Dr. Praful B. Desai, in Dr. Desai's case, the issue of virtual recording of evidence has been accepted. So it's legally permissible even then. The only problem that you face is that though we have rules in place, we do not have the infrastructure to secure non-interference by witnesses. And it can be done on a case-by-case basis, but we really have to have robust infrastructure. And when the Delhi High Court rules say that we'll create courtrooms, we'll create rooms where lawyer commissioners will sit and get evidence recorded to ensure that demeanor is noted, and that the witness is not interfered with, which means the legal profession also earns some benefits. At the same time, that infrastructure, the physical infrastructure has to be placed, which will provide both for the safety of the commissioner and the witness. So that's one very important consideration. I think this is an issue that will need to be addressed. And we are honestly, the fact is we are just learning as we go along. I hope I've answered the question.
Yes, sir. So, sir, we'll next move to Saurav's question. He asks, so presently the e-courts project is being driven primarily by the judiciary itself. So considering the fact that it is an administrative exercise, do you think that this process could have been delegated to the executive? On a similar note, do you think that there is a need to separate the judicial and administrative duties of a judge? And if yes, what should be the way forward?
I think we need to look right now, those handling the administration are judges committees and judicial officers. You have some administrative officers who join the the courts and work as registrars on the administrative side. But and in the past, the Supreme Court has been calling officers from the Indian Information Service to deal with certain aspects. But I think it's important that we have lateral introduction of people, professionals, whether tech professionals, management professionals, who will work with lawyers and judges and manage things like caseload, and especially virtual caseload. So all of this needs to be done and on priority. The nature of work that a judge does may involve some amount of administration, but I think we need more specialized people to handle the administrative and the technological part. We've had the benefit that we've had some very bright people working who understand technology, but the fact is, the changing technology is so great that what you understand today as a non-technical person, keeping with the other pressures that judges work under in terms of work constraints and time, don't leave you with enough time. So while you may understand the implication of technology, you are not a technological expert. And therefore, I think it's important that we need to broad base the administration of the court system. There needs to be perhaps some representation from the government, but that always is there. There can always be people coming in on deputation. There is no problem with that at all. So that can easily be done. People do come in on deputation to the courts. They come within the court system. They come from outside the court system, but I don't think there's an issue on that at all. And I think we will just need to see, do we want bureaucrats? In the sense, do we want administrators, or do we need people with management skills who may not necessarily be bureaucrats? And then for that, you need lateral entries, don't you? That will need to be provided for. What else?
So then we can move on to Anjali's question. She asks, till what extent do you think would virtual case hearing be conducted if we get back to the normal proceedings?
Anjali's question is, just repeat that again.
Sir, till what extent do you think would virtual case hearings be conducted if we get back to the normal proceedings?
I think it'll be a mix. Now. Virtual courts are here to stay. I believe efficiencies can be enhanced by doing trials or voluminous cases in physical court, whereas while doing virtual hearings, and the hybrid model will have to be made to work. The hybrid system has been requested by the Delhi Bar Council and MP High Court, and as I said, Allahabad, Nainital are all, Shimla are all allowing virtual courts. Punjab is allowing virtual courts. Rajasthan allows a hybrid system. So it's going to be hybrid in part and partly virtual. Look, I'll tell you what. When there are very voluminous records and files, it may be better and faster to be in courts, because look, eventually we are working at improving efficiencies. And the problem that I foresee, and I see this often enough and all the time, is that the planning of a court day will have to be made in a system where you do virtual half the day, physical half the day. Today what happens is, if it's virtual and physical both, even if I accept a virtual hearing and I go to court physically, I go to court building, I don't know whether I'm going to get a proper signal there or not, or if I'm going to get an undisturbed. So I'm going to be sitting in the stairwell or in a corridor. I may not have access to a room. Whereas I'll be very honest, as most senior lawyers do, they have multiple screens and multiple devices, and they're doing multiple hearings at the same time. Well, not at the same time, but one after the other. So those efficiencies are there for a lot of us, but we have to make sure that the system is democratic, that access to justice to the litigant and to the lawyer who's less privileged is also to be maintained, and all of this will have to be seen.
Okay, so then we'll take one last question of Subhajit. He asks, many of us who aspire to be a litigator in the future plan our careers ahead as starting off in a law firm for the first 3 to 5 years, which should provide us with a stable form of income and then go to switch over to litigation. Do you think such a trajectory is advisable, and what are the potential losses that one could occur on the litigation side of the career?
Look, there is a serious problem with whether it's law firms or litigation. There's not enough hiring that's going on. I'll be very plain with you. There's lesser hiring, though most of the law firms are making more profits than before. They're doing a lot more business, they're doing a lot more work, so revenue streams have not really suffered. But having said that, I think in a year's time, maybe 6 months, after 6 months, things will be streamlined. A law firm revenue is far superior. In a litigation career, the revenue is much less. A law firm gives you quality. General litigation gives you numbers. Speaking for myself, if you can afford it financially, better to play the numbers game, work in an office where there's a lot more drafting, a lot more filing, and then go to high-end work in a law firm. Though, frankly, law firms like people fresh out of college and they pay very well, so it's very tempting for a young professional, especially if you don't have a background in the law. But you must also keep in mind that with a lot of law firms, most law firms, there is a glass ceiling. So while they pay you well, they will make you partners, which is really a job. Some will give you some minuscule equity, 2, 3, 4%. They'll put you on the managing committee. But these are really family or proprietary concerns. So it's a choice you have to make. I'm also of the view that perhaps as time goes by, the institution of senior counsels may also wane. as more and more law firms are now having good litigators who choose to remain in law firms but also argue matters. They don't just want to brief everybody even for an adjournment, senior counsel even for an adjournment. So that change is very vibrant. We're going more, our law firms are becoming more Americanized than like the British solicitor firms where solicitors never argued matters. So that's a substantial change. Okay. Having said that, the litigation, private litigation does not pay that well. So you all also have to see the economics of what your career choices are. Right now, the idea is if you get a good job, which can train you well in the next 1.5 years, please take it. Because there are limited jobs available, limited good jobs available, especially in the private litigation domain. Not very limited, but still. Earlier people wouldn't mind keeping an extra junior or two. But today, with 2 lockdowns, most people are wary whether they can afford to increase or expand their workforce with the apprehension that if there's a 3rd lockdown or a 4th lockdown, then where will they pay revenue from their own pockets, isn't it? Okay.
Yes. Thank you, sir. Sir, I'll just take a few minutes of yours to inform about our cell. Our cell, NUJS Litigation and Clerkship cell, is dedicated only for litigation and clerkship works. Like it organizes workshops and seminars, webinars for students, because in law schools, like primary focus is on corporate jobs or corporate firm jobs, but there is not a forum where litigation and clerkship cell is promoted. So for that purpose, we have like founded this cell, and we also host a few workshops on basics of litigation and all the skills or the experience and everything that may be required when we go and practice litigation. So sir, I'd like to like informally request you, if you may have time anytime during this year or next year, to please come and give a workshop too for the students. Like we would be very grateful for the same.
Yeah, I don't mind doing it. I am now, just to clarify, I am now teaching at the NLU Dwarka. I'm a visiting professor. I've been teaching at Jindal last year. Now this year I've accepted a 3-year term as visiting professor at NLU Dwarka. So that's going to be a little time constraint, but we'll do something for you guys. And
Yes,
Anjali
sir.
Khanna, that book that you wanted to know is an interesting book which you may want to read. It is by a gentleman called, just give me a minute. It is by a gentleman, Why I'm Not a Hindu, a Sudra Critique of Hindutva Philosophy, Political Culture and Political Economy, by Kancha Ilayah, Ilaiah Shepherd, Shephed. It's an interesting book. I'm reading it right now. I found it quite interesting. Have a look. Okay. Okay. Any other questions?
I think we can wrap this up, sir. And
Thank
thank
you
you
so
for your
much.
help and everything. I'll ask Arunima to give the formal.
Good evening, sir. On behalf of the LCC, I would like to extend heartfelt gratitude towards you for the enlightening session we had. Your comments on how the virtual platform has affected the legal arena gave us a new perspective on how the administration of justice has been transformed in the past 2 years. You talked to us about the logistical issues faced by courts in this virtual setup, such as the use of multiple platforms for video conferencing, which leads to non uniformity, and the problems posed by the widespread lack of digital literacy. Your opinions on the bright future of the virtual courts, especially with respect to their contribution to the reduction in the carbon footprint and the increase in the efficiency of courts, have been enlightening for us. It was indeed a great learning experience for all of us present here. Thank you, sir, for taking our time to speak to us today. I
My pleasure.
would I would also like to thank the members of the GB for attending and contributing to this fruitful session. Yeah, that's about it.
I must also thank my colleague Krishna Multani, who helped me with this talk. He's the one who did a lot of research, gave me a lot of input. So thank you all, and thank you, Krishna.